Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2 of Jefferson County, Texas. You have been asked to come to court this morning for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what your rights are, what your options are concerning your case. And we're here to tell you the case that you've been charged with. Now, the case that you have been charged with is a criminal case. We handle criminal cases in this court. Criminal cases are divided into felonies or misdemeanors. We handle misdemeanors. Felony cases are commonly referred to as your more serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not that mean that they're not serious? It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, you don't have to worry about that punishment because we handle misdemeanor cases in this court. Misdemeanors are divided into 3 categories. We'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is usually from $0 to $500. You only can be given a fine. You cannot be given jail time if you are convicted of a Class C misdemeanor. Now, the Class C misdemeanors come to this court from the JP court, which is the justice court, or they come to this court from the municipal court or the city court. And the way they come to this court is by appeal. Now, once the case is appealed up to this court, then the punishment range does not change. The punishment range is the same, and that is minimum $0 to a maximum of $500. Now, if a person fails to pay the fine, or if a person if their fine was converted to community service and they fail to perform the community service, then the court can issue what is called a capias pro fine. And basically what that means, it's a warrant for your arrest to either pay the fine or sit out the time in jail. And if a person sits out the time in jail, they will receive $100 credit for every day that they spent in jail that will go toward the fine and court costs. Now, The next highest misdemeanor is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to maximum 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for one of two types of probation. One type of probation is called adjudicated probation. We refer to it as regular probation. And the other type of probation is called unadjudicated probation. We refer to that as deferred adjudication. Now, with the deferred adjudicated probation, which is unadjudicated probation, you do not have a conviction on your record. And if you successfully complete unadjudicated probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure. And what a non-disclosure is basically just means that your record will be sealed to the general public. That is, the general public, we can't tell the general public that you received deferred adjudication for this offense if you receive unadjudicated probation and if you successfully completed and you were given a non-disclosure. Now, if you fail to complete your deferred adjudicated probation, your probation may be revoked. And if your probation is revoked, you may get a conviction. Okay. Now, the next type of probation is called adjudicated probation. You have unadjudicated, which does not result in a conviction, and you have adjudicated, which does result in a conviction. And with the adjudicated probation or the regular probation, you do have a conviction that at the time that you get placed on probation. However, if you successfully complete the probation, there's something that is called judicial clemency, where the court, that is the judge, can set aside the conviction, and you will no longer have a conviction on your record. Now, in order to qualify for that, you have to successfully complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged from the probation. If those three things happen, the court has the discretion to set aside your conviction, and you will no longer have a conviction by virtue of judicial clemency. However, if you get a subsequent conviction, that is, if you get another conviction later on, then the case that you receive judicial clemency on can be brought back up, it can be revived or resurrected, and it can be used against you. And if you try to get a license with CPS, they can deny giving you a license, or if you have a license, they can suspend or revoke that license. Now, I'm going to go over the paperwork with you on the clipboard. You should see a document on the clipboard that is titled Judge's Explanation of Rights to Defendants Without Attorney. I'm going to go over that document with you. And basically it says that you have a right to have an attorney. Now, as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire an attorney. If you want an attorney, but you do not have enough money to hire an attorney, you would need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, the financial questionnaire that you would have to fill out is another document on that clipboard that is titled Jefferson County Affidavit of Indigence. And you need to turn to that document. On that document, what you would have to do is you're going to fill out the first page. And then at the bottom where it says monthly income, it's like what your take-home pay. You're going to fill out, you're going to answer those questions to the left at the bottom, and then you're going to total it. And then on the opposite side of the page, where it says monthly expenses, if you have any expenses like you're paying rent or mortgage, you'll put that there. If you do not have any, just put 0. And so you're going to put your monthly expenses in each one of those categories. Now, for example, transportation. When you're looking, if you have a car, of course you have paid for gas, whatever your monthly expenses on that. If you're paying a car note, whatever your monthly expense on that is. And also, if you are paying car insurance, you're going to add all those up, and that's going to be your total for transportation costs. And then, like as I mentioned earlier, you're going to fill out each one of those categories, and then you're going to total what the monthly expenses are. The total expenses, rather. Now, you go to the next page, the page that has defendant's oath. It should be a page that has defendant's oath. You will date it, which is the 27th day of August of 2024. You're going to read that section, and then you will sign where it says defendant's signature and date, August 27th of 2024. Then you're going to go to the bottom of that document where it says unsworn declaration. You will fill out unsworn declaration by defendant. You will fill out that section, and that's it. That's all you would have to fill out. For those of you who will be applying for a court-appointed attorney. If you're not applying for a court-appointed attorney, you don't need to fill out the affidavit of indigence. Now, if we go back to the judge's explanation of rights to defendants without an attorney, it says that you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, that sentence is only for people who will be waiving their right to have an attorney or giving up the right to have an attorney, and they are designed to represent themselves. Then, if you waive your right to an attorney, then you would have to read and sign the other document that's on that clipboard that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding the trial. That's only for people who will be representing themselves. If you are designed to hire your attorney, or if you're designed to get a court-appointed attorney, you do not have to read and sign the waiver of counsel for purposes of entering a guilty plea or proceeding the trial. Okay? And for those who will be waiving their right to an attorney and representing themselves, they will have an opportunity to talk to the prosecutor. We have 2 prosecutors at the table to your right. You can talk to one of them about your case. And the reason why, because you are representing yourself. In essence, you are acting as your own attorney. So you'll have a right to talk to them. Now, again, you will not be able to talk to them unless you first read and sign the waiver of counsel for purposes of entering a guilty plea or proceeding the trial. And it states as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 27th day of August of 2024 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to appoint counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that's titled defendant, and you will date it today's date, August 27th of 2024. Now, you should be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, that is, if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, the judge's explanation of rights to defendants without an attorney. In bold letters, it states, defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney or to give up your right to have an attorney to represent you, and you desire to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will date it, the day's date, August 27th of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. That area over there where you see those 12 chairs, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors to serve in your case. The jurors will listen to all the evidence. They will listen to the arguments of the counsels. They will deliberate, and then they will decide whether to find you not guilty or guilty of your charge. You also have a right to waive or give up your right to have a trial by jury. If you waive or give up your right to have a trial by jury, then your case will come before the court in one of 3 ways. One way it can come before the court is by way of a trial, by way of a bench trial. That is a trial without a jury. It is a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to all of the evidence, the arguments of counsels. Then the judge will apply the facts to the law, and then the judge will decide to find you either not guilty or guilty of your charge. Another way that your case, the second way that your case can come before the judge is by way of an agreed plea bargain. A plea bargain is a way that you and the state or your attorney in the state has reached a settlement in your case, to settle your case. And then that case will come before the judge by way of an agreed plea bargain. And the judge can do one of 2 things. The judge can either accept or reject the plea bargain agreement. If the judge rejects the plea bargain agreement, that is, if the judge does not accept the agreement that you have made with the state, and the judge rejects the plea bargain agreement, you have the right to take back or withdraw your plea. For example, let's say you and the state have reached a plea bargain agreement, and the agreement is for you to serve 1 day in jail. And the judge says, well, I'm not going to follow that agreement. Well, you say, well, judge, since you're not following that agreement that I made with the state, I take back my plea. In essence, I'm not pleading guilty. I'm not pleading no contest to the charges. You have a right to do that. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case. An appeal is you would like to have a higher court to review your case to see whether or not this court committed an error by convicting you or whether or not you have been wrongfully convicted. Then it will go up to the higher court. In order for your case to go up to the higher court to appeal your case, in order for you to appeal your case, if the judge follows the plea bargaining agreement or accepts the plea bargaining agreement, you have to get the judge's permission to appeal the case. And if you get the judge's permission, then the case will go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. They will review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. They can do one of two things. They can either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over, or they can send the case back down to this court and order this court to give you a whole new trial. Or if they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals. They're located in Austin, Texas. You'll have to file what we call a pro se petition for discretionary review. Now, pro se means that you'll be representing yourself. You will not have an attorney representing you. You'll be representing yourself. And you'll be petitioning the Texas Court of Criminal Appeals to review your case. You see whether or not your appeal should have been granted, whether or not this court committed an error by convicting you, or whether or not you was wrongfully convicted. Now, they can do one or two things. The Texas Court of Criminal Appeals, that is. They can either grant or deny your pro se petition. If they grant your pro se petition, then they can simply find you not guilty and case is over. Or they can send the case to the Ninth Court of Appeals with orders, or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your petition, then at that point, your conviction will stand. Now, the other way that your case can come before the judge, besides the way of a bench trial or an agreed plea bargain, it could come to the court by way of an unagreed plea bargain agreement. Unagreed means that you and the state have been negotiating, but you have not been able to reach an agreement to settle your case. In essence, you couldn't agree on what the punishment is. And so since you could not agree on what the punishment is, you want the judge or the court to decide what the punishment will be. That is, we call that an unagreed plea bargain. Okay. Now, as a defendant in a criminal case, you also have a right to have witnesses that come to court. Witnesses sit in that chair over there. We call that chair the witness stand, the chair that has the microphone in front of it. Now, what witnesses do, they can testify either for you or against you. If you're representing yourself, you can ask them questions. If you have an attorney representing you, your attorney can ask them questions, and we call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses that come to court. If you waive or give up the right to have witnesses that come to court, that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in your case. Now, you also have a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify in your case. I know you look at some of the law shows on television, you hear a person say, well, I take the fifth. In essence, they're saying that I'm not going to testify. And you have a right not to testify in your case. That is, the state, the government, the DA's office cannot force you to testify against yourself in your case if you exercise or invoke your Fifth Amendment right against self-incrimination. Now, you can waive it, and if you waive your Fifth Amendment right against self-incrimination, that simply means that you will be testifying in your case. You also have a right to have discovery. And what discovery is, you have a right to see the evidence that the state have against you, the evidence that the state has in its file. In essence, you have a right to discover or see the evidence that the state has in its file. Now, that is, you have a right to see witness statements, your statements, police reports, lab reports, video record. You have a right to see video recordings, listen to audio recordings, see photos, and you have a right to have access to any documents or instruments that they may be using in your case. Now, you also have a right to waive or give up the right to have discovery. And if you waive or give up the right to have discovery, you will not be having access to the evidence that the state will be using against you in your case. Now, everyone that's here for arraignment, you you're here because you've been arrested and you out of jail on bond. You're either out on a cash bond, which means you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on a PR bond or a personal recognizance bond, which means that you were released under your own personal recognizance with a promise to appear here in court. Now, every day that you have spent in jail on this case, it can be used as credit towards your punishment. Now, when I say every day, for example, that even includes 1 minute. For example, let's say you were in jail, you got booked into jail at 11:59 p.m. You booked out of jail at 12:01 a.m. the next day. They consider that you was in jail 2 minutes, but they consider that 2 days because it's 2 different days. Okay, so every day that you spent in jail can be used as credit toward your punishment. So, for example, if you spent 5 days in jail and you're in the state of reaching a plea bargain agreement for you to serve 5 days in jail, you will not have to serve any more time in jail. Why? Because you'll be given credit for the time that you've already served. Therefore, you will not have to serve any more time in jail. However, if the state is offering 7 days in jail and you serve 5 days in jail, that means you would only have to serve 2 days in jail because you have 5 days credit that will be subtracted from the 7, which leaves 2. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. You receive $100 credit for every day that you spent in jail. So, for example, if you spend 5 days in jail, that's $500 credit that can be used toward your fine and court costs. So if the state is offering fine and court costs of $500, you've been in jail 5 days, then you won't have to pay anything because the time that you spent in jail has already paid it off. Now, if the state is offering fine and court costs of $700, you spent 5 days in jail, which is $500, then you will only have to pay $200 because we're going to subtract the 500 from the 200. I mean, 500 from the 700, and that leaves 200 that has to be paid on the day that you dispose of your case. Now, if you can't pay the fine on the day that you dispose of your case, no problem, because we could put you on a payment plan. That is, we could require that you pay the balance over a period of months. You pay so much a month until it's all paid off. Now, for some people, even if we put you on a payment plan, you might not be able to pay it off. No problem, because we can convert your fine and court costs to community service. That simply means that for every 1 hour of community service that you perform at a nonprofit organization in Jefferson County or in our region, then you will receive $12.50 that will go toward your fine and court costs. So if you work an 8-hour, if you do 8 hours of community service in one day, that's $100 that will go towards your fine and court costs. So in the scenario that I gave you earlier, you owe $200. You work 2 8-hour days, that's $200 because it's every 8 hours is $100. And so that'll be $200 that will be paid towards your fine and court costs. And then you will pay the balance and you will not owe the county any money. Okay. Now, Jefferson County has a program for first-time offenders. So if you've never been in trouble before, you're here for the first time, then Jefferson County, the district attorney's office, that is, they will dismiss your case. It's called pretrial diversion. It's a program called pretrial diversion. They will dismiss your case. And once you successfully complete the program, you can get the case removed. We call it expunged. That means erased, deleted, or removed from your record. You won't have a criminal record on this case. Okay. Now, in order to qualify for the program, it has to be your first time getting in trouble. And then two, it cannot be an offense involving unlawful carrying of weapons or resisting arrest. And three, you have to have an attorney to assist you with submitting the application to the district attorney's office. If those three things happen, you get into the program, you complete the program, they will dismiss your case. Well, they'll dismiss the case when you get into the program, and if you complete the program, you can get it erased, deleted, or expunged from your record. It will no longer be on your record, your criminal record. Now, if you are a veteran of any one of the branches of the United States military, the Jefferson County District Attorney's Office has another program for veterans only. Only thing you have to do is be a veteran of any one of the branches of the United States military, and you can participate in a program that is called Veterans Court. With Veterans Court, they'll put you in the program, you complete the program, and once you complete the program, you can get an expunction, not an expunction, but a non-disclosure. A non-disclosure, as I mentioned earlier, is the way where your record is sealed to the general public. The general public will not have access to it. Okay, when I normally notice I use the word general public. General public is most of the public. Now, the government can have access to it, but the general public cannot have access to it because your record will be sealed from the general public. Now, this court, County Court at Law number 2, has a program that is called the Community Safety Initiative. Is it a program that started within the first 100 days of taking office in March of 2017. So we've had this program for 7 years. This program is designed to address the issue of recidivism. And that is people commit crime. Recidivism means when people commit crimes over and over, then we address that issue. The way we address it is through the Community Safety Initiative, the CSI program. That's what Community Safety Initiative stands for. The CSI program is an acronym that stands for Community Safety Initiative. And in that program, we have partnerships with agencies in our community. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is our local mental health center in the Southeast Texas region. Now, Spindletop has the expertise to address your mental health needs. Now, what Spindletop will do initially, they will conduct a private interview either here in a private conference room or at their facilities, or they may conduct it by phone, whichever is convenient for you. They have the ability to do an assessment. They also have the ability to develop a treatment plan, either outpatient, inpatient, depending on your mental health needs. Now, in order to qualify for the program, you do not have to be insane or incompetent. You could just merely suffer from anxiety or depression or any other host of mental illnesses. And they have the ability to address your mental health needs. If you have issues with drugs or alcohol, Spindletop also has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. We also have a partnership with our local Drug and Alcohol Council. They have a program that is called OSAR, OSAR, which is an acronym for Outreach, Screening, Assessment, and Referral. Both ATAR and OSAR are drug and alcohol recovery programs that can address your drug and alcohol needs, issues. Now, with these programs, they have the ability to do a screening, assessment, and they can develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed and do not have a job, or you're looking for a better job, we have a partnership with our Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE is an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of the areas that you're trained in or that you select, they will help you to get a job in the area that you're trained in. So one of the benefits of that program is, I know sometimes people get training and they say, oh, I can't get a job. And they may not be able to get a job because of their criminal record or something like that. However, with CICE, where you cannot get in the door, CICE, with that program, they can get you in the door and get the job for you, regardless of your background. The other thing is, if you have not graduated from high school or you do not have a GED, CICE has a GED program that's a graduate equivalency, where you can get your graduate equivalency diploma. And all of these programs that I just mentioned are free. It does not cost you anything but time. And I like to say in this course, we do not just give time, we take out time. And that is, we do, and what I mean that we do not give time, we take out time. And the reason why we do that is because we believe that if we don't just arrest the problem, but if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say, when you come to County Court at Law Number 2 of Jefferson County, Texas, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community. Why? Because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know, and we can direct you to the people that you need to talk to get into any one of these programs. And we also have brochures. Now, one of the other benefits of this program is the fact that all of these programs that I just mentioned can be used as community service. So let's say, for example, you were required to pay a fine, but you couldn't pay your fine. And so we converted your fine to community service. So every 1 hour that you're in GED class, or 1 hour that you're in training to get a job, or 1 hour that you at Spindletop getting treatment for your mental health needs or drug and alcohol issues, every 1 hour that you spend in any one of these programs, $12.50 will be going toward the payment of your fine and court costs. 1 hour will be going toward community service, and you're participating in the program. So I tell people this all the time. You're not just killing two birds with one stone, you're killing three. You're in the program, you get community service hours, and you're paying your fine and court costs. So if you're interested in any one of these programs, just let us know, and we'll be happy to direct you to the persons that you need to talk to get involved in one of these programs. Now, at this time, we have some people from Spindletop. We have Deputy Hinton and Cloyd. They're going to come before you rather, and just give you a little bit more information on the program that Spindletop has to offer. Deputy Hinton and Cloyd.
Thank you, John.
You're welcome.
Morning. My name is Steve Hinton. I'm a licensed mental health deputy by the state of Texas, commissioned here with the sheriff's office. I'm here with Chloe. Now, Chloe is a qualified mental health deputy and recent mental health professional. The reason we are both here this morning in this courtroom is because the judge cares about every single person who comes to the bench. What the judge has found, which statistics prove, is those who have legal issues commonly have mental health needs, use disorders, and sometimes just a lack of community resources to help you.
So what they mean by this is a lot of people have things like depression or anxiety that arise when just going through the criminal justice system and judicial system as a whole. And also there's a lot of programs that are well funded but not well advertised.
Maybe this is your first time being forth, could be your 10th time being forth, you still hope. In fact, what we're offering you today has the ability to change your life. We're going to need something from you. We're going to need you to share that need with us so we can see best how to advocate and help you in whatever situation it may be. And Chloe's gonna explain exactly how you can do that very privately.
So when you guys came in, everybody received this paper right here. It actually serves as a baseline HIPAA consent form for y'all to share y'all's contact information only with me. Now, anything y'all put on this document, it'll only be shared with me. It gives y'all the option of, speaking now to me if y'all need to privately, or me contacting y'all via, phone call or text message or email. So if y'all feel that y'all need to, fill out anything like this, it doesn't mean that you definitely need assistance today, but it gives me a way to contact you guys and see if y'all need any assistance in the future.
I also have a card here that I want to give everyone before you leave here today. It has our office number on there. It also has a 1-800 number, crisis number on there. If you ever find yourself in an unsafe place, you can call that number and get help immediately. And just shortly, the court is going to go into recess. When it goes into recess, we'll be able to come out there, we'll visit with you and answer the questions you have. I'll be handing this out to everyone. And we'll be picking up those documents as well for those who want to turn it in. Thank you very much. Thank you, Your Honor.
Okay, thank you, Deputy Hinton Clint and Chloe. Now, ladies and gentlemen, the paperwork that you have on the clipboard, we're going to pick up that paperwork from you. Now, if you need any help to fill out that paperwork, we have our court personnel who's here, who is ready and able to assist you with filling out the paperwork. Now, it's going to take us a few minutes to pick up the paperwork from everyone. And once we pick up the paperwork from everyone, we will call you up before the bench or before the judge, one at a time. And then once we finish in here, you'll move to the court coordinator. Your case will be just taken care of today. And then if you are hiring an attorney, or if you applying for a court-appointed attorney, as I mentioned earlier, or if you're representing yourself, you'll have the opportunity to talk to one of the prosecutors. Now, if you need to use the restroom, there are two restrooms. There's some restrooms that's right by the courtroom and right outside in the hallway. One courtroom is for the men. That's in front of County Court at Law number 3, which is right next door. That's the men's restroom. The women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, you'll be allowed to use the restrooms and you'll be allowed to go out into the hallway. Now, do not leave the courthouse. If you leave the courthouse and your name is called, then your bond can be forfeited and a warrant can be issued for your arrest. Okay, so this is gonna take us a few minutes. Just be patient with us. Again, as I mentioned earlier, if you need any help with your paperwork, we have our court personnel here. Just simply raise your hand and they'll be happy to assist you with the paperwork. Okay, so at this time, the court will be in recess. Those of you who need help, just raise your hand and our court personnel will come out and help you. Jefferson County Code Law number 2 is back in session. Court is in session with the arraignment docket. First case is cause number 23CCCR 1706. Case is styled the state of Texas versus Keelan Jaquan Oliver. Mr. Oliver, is that your full name?
I have the Lonnie in my middle name too, so
What is it?
it's Keelan Jaquan Lonnie Oliver.
Okay. How are you doing, Mr. Oliver?
Okay.
That's good. Now, Mr. Oliver, you're represented in your case by your attorney, hold on a minute. You're represented in your case by your attorney Charlie Rojas. Attorney Rojas, how are you doing?
Doing well, Judge.
That's good. The state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm doing great, Judge. How are you?
I'm doing fine. Thanks for asking. Now, Mr. Oliver, I have before me a motion to dismiss. Is that correct, state?
Yes, Your Honor.
And I'm signing the motion to dismiss this misdemeanor case. So your case in this court is dismissed. The attorney's going to get a copy of this dismissal in a few minutes. And Mr. Oliver, you can free you and follow the bailiffs, and you have a blessed day.
Yes, sir.
All right. Dipps County Court at law number 2 is back in session. Court is in session with the arraignment docket. Next case is cause number 24 CCCR 1476. The case is filed in the state of Texas versus Sidney Monet Edwards. Ms. Edwards, your full name is Sidney Monet Edwards?
That's correct.
Ms. Edwards, would you please raise your right hand? Ms. Edwards, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Edwards, you may put your hand down. How are you doing, Ms. Edwards?
How about you?
I'm doing fine. Thanks for asking. Ms. Edwards, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah.
Is this your signature on the line that's titled defendant?
Yes, sir. That's
And
mine.
are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Ms. Edwards, before you signed and initialed this document, did you read the document? Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Ms. Edwards, I've read your answers. Your case is going to be reset by our court coordinator. Just have a seat in that first chair on the wall, wait for your name to be called. Once your name is called, go to the window. Once you finish there, you're free to go and you have a blessed day. Next case is cause number 23 CCCR 2344, case of style state of Texas versus Dwight David Guillory. Mr. Guillory, your full name is Dwight David Guillory. Ms. Guillory, would you please raise your right hand? Mr. Guillory, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Guillory, you may put your hand down. How are you doing, Mr. Guillory? You doing all right?
Great.
Okay. Now, Mr. Guillory, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Now, Mr. Guillory, before you sign and initial this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Mr. Guillory, your case is going to be reset. Once your case is reset, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. Next case is cause number 24 CCCR 1174. Case to style of state of Texas versus Marcus Holt. Mr. Holt, your full name is Marcus Holt. Holt, please raise your right hand. Mr. Holt, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You may put your hand down. How are you doing, Mr. Holt?
I'm blessed.
That's good. Can't be better than being blessed. Now, Mr. Holt, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, Your Honor.
Is this your signature on the line inside of defendant?
Yes, Your
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Honor. Yes,
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
yes,
On page 2 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
yes, Your Honor.
Mr. Holt, before you sign and initial these documents, did you read the documents?
Yes, Your
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Honor. Yes, Your Honor.
Mr. Holt, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Jennifer DeLodge. Attorney DeLodge is going to, will be given information to contact you, and you will also be given information to contact her. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go and you have a blessed day. Please have a seat in the first chair on the wall.
No, that won't happen until next time you take it to court. If you have a cash bond.
Huh? Okay, next case is, the next two cases, style State of Texas versus Christopher Stevenson, cause number 24 CCCR 0458, and cause number 24 CCCR 0459.
Yes, sir.
Good morning, Mr. Stevenson. Your full name is Christopher Stevenson?
Yeah, Christopher Sean Stevens.
Okay. Mr. Stevenson, would you please raise your right hand? Mr. Stevenson, do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Stevenson, you may put your hand down. How are you doing, Mr. Stevenson?
I'm okay. How about yourself?
I'm doing fine. Thanks for asking. Mr. Stevenson, I have before me two dockets. The first docket is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
Mr. Stevenson, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Stevenson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your cases is Ms. Lori Perazzo. Attorney Perazzo will be given information to contact you. You will also be given information to contact her. Our court coordinator is going to give you that information. But before she gives you that information, I need to give you some bond conditions. Mr. Stevenson, could you please step to your left? Take these bond conditions.
Yes.
Okay, you can step back. Now, Mr. Stevenson, the document that you have just been handed is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
Okay, I'm going to go over these bond conditions with you, and it states as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that
Yes,
condition?
sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 and 4 does not apply, however, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a political subdivision or state agency. Do you understand that condition?
Sir.
Now, Mr. Stevenson, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Now, Mr. Stevenson, our court coordinator is going to give you your paperwork. Have a seat in that first chair on the wall. When she calls your name, go to her window. And then once you're finished, you're free to go and you have a blessed day. Next case is cause number 24-CCCR 1340, case of style of the state of Texas versus Jacoby Jermaine Sherman. Mr. Sherman, your full name is Jacoby Jermaine Sherman.
Yes, sir.
Mr. Sherman, would you please raise your right hand? Sherman, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Sherman, you may put your hand down. How are you doing, Mr. Sherman? I'm doing fine, thanks for asking. Mr. Sherman, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature on the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Sherman, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Sherman, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day.
Thank you.
Please have a seat in that third chair on the wall. Next case is cause number 23-CCCR 2027. Case is. I pointed Provo on him, right? Which one? Who's that? That was Mr. Sherman. Okay. That's Marlboro. Okay, order in the court. Okay, let me see, I pointed Provo on Mr. Sherman. Okay, the next one. Oh, I got it out of order. Provo, Sherman. Jacob. Next case is cause number, I have two cases. Cause numbers 23 CCCR 2026 and cause number 23 CCCR 2027. Both cases are styled state of Texas versus Marvin Mosley. Mr. Mosley, your full name is Marvin Mosley?
Yes.
Mr. Mosley, would you please raise your right hand? Mr. Mosley, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Mosley, you may put your hand down. How are you doing, Mr. Mosley?
Fine, and yourself, John?
I'm doing fine, thanks for asking. Mr. Mosley, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled?
Yes.
And are these your initials on the line that state you'd like to apply for full appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Now, Mr. Mosley, before you sign and initial these documents, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Mosley, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator. Sorry, that door is locked. Oh, no. And Mr. Vasquez will be given information to contact you. You will be given information to contact him. Our court coordinator will give you that information. And once she gives you that information, you'll be free to go. And you have a blessed day. Now, Mr. Mosley, before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Mr. Mosley,
Yes, sir.
do you see that document?
Yes, sir.
Now, Mr. Mosley, I'm going to go over this document with you. And it reads as follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. You understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and a test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 and condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states as follows. The defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07, the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Mr. Mosley, do you understand that condition?
Yes, sir.
Now, Mr. Mosley, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Mosley, you're going to have a seat in that third chair on the wall. Wait for your name to be called. Once your name is called, you'll be free to go. And Mr. Mosley, you look real nice today.
Thank you, thank you.
All right, just have a seat.
Yeah.
Jada Tompkins, come forward.
And the door right here is off.
Good morning. Miss Tompkins, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You swear to tell the
Yes,
truth,
I
the
swear
whole
to
truth,
tell
and
the
nothing but the truth, so help you God? Okay,
Yes, I swear.
okay, you may put your hand down. Now, Miss Tompkins, how are you doing? I'm doing fine, thanks for asking. I'm Miss Tompkins. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
Is this your signature on the line that's titled defendant?
yes,
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? On page 2 of the same document, there's a signature on the line that's titled defendant. Is this your signature?
yes, sir.
Ms. Tompkins, before you sign any initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Okay.
Is everything in this document, in these documents, true and correct to the best of your knowledge?
Yes.
Ms. Tompkins, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day.
Yes, sir. Thank you.
Okay. But just please have a seat in that first chair on the wall. Jules Savoy. Mr. Savoy, your full name is Jules Savoy?
Yeah.
Mr. Savoy, would you please raise your right hand? You swear affirm and tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. How are you doing, Mr. Savoy? Not too great? I hope you'll be feeling a little bit better after you leave here. Now, Mr. Savoy, I have before me two documents. The first document is titled Judge's Explanation of Right to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled defendant?
yes,
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
yes,
Mr. Savoy, I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of the same document, there's a signature above the line that's titled Defendant's Signature. Is this your signature?
Yes.
Now, Mr. Savoy, before you signed and initialed these documents, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Savoy, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney William Wilkerson. Mr. Wilkerson will be given information to contact you. And you will be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day now. Before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Mr. Savoy, do you see that document?
Yes.
And Mr. Savoy, I'm going to go over this document with you. And this document states as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are subject to the additional conditions. Number 1, defendant is prohibited from, the defendant shall not commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition 3 and 4 does not apply. However, condition number 5 does apply. Condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07, the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Question.
Okay,
They suspended me until December, my commercial license.
okay. This is just basically saying you cannot possess or you cannot possess a firearm or ammunition. You know what possess is?
Full-time job.
Huh?
Speaking on the full-time job, yeah.
It says unless you are a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee.
Yes, sir.
Okay. All right. Now, do you understand condition number 5?
Yes, sir.
Okay, and do you understand all of these conditions?
Yes, sir.
If you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in Jefferson County jail. Do you understand that?
Yes.
All right.
You're right.
Just have a seat on that 3rd chair on the wall. Wait for your name to be called. Did they, yeah. Garrett, Cody, Baggett. Okay. For the record, your full name is Garrett Cody Baggett. Badgett. Mr. Badgett, would you please raise your right hand, Mr. Badgett? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Badgett, you may put your hand down. How are you doing, Mr. Badgett?
Good, all right.
Okay, now, Mr. Badger, you have a right to have a record. That is, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a record. Do you waive or give up your right to have a record?
Yes, sir.
You do? Okay. Now, Mr. You said Badgett.
Gotcha.
Badgett. Okay, Mr. Badgett. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Mr. Badgett, are these your initials on the line that states you want to waive your right to attorney and represent yourself?
Yes.
And is this your signature on the line that's titled defendant?
Yes, sir.
I also have a document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Badgett, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge? Okay. Now, Mr. Badgett, I also have before me a document. Hold on a minute. Get to it. Okay, Mr. Badgett, I have before me a document that is titled information sheet. This information sheet is on my computer and it was filed by the Jefferson County District Attorney's Office.
Okay.
In this information sheet, Mr. Badgett, it alleges that you, Garrett Cody Badgett, on or about August the 8th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Badgett, do you understand what you have been charged with?
Yes.
And to this charge, Mr. Badgett, how do you plead? Guilty, not guilty, no contest?
No.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Badgett, I also have before me a document that is titled misdemeanor plea admonishment on the laptop. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two sets of initials. The first set of initials is below a paragraph that is titled waiver and is on a line next to a box that's checked nolla contendere, which means no contest.
Right.
Did you place your initials on this document?
Yes, sir.
The second set of initials is below a paragraph that is titled discovery, admonishment, and is on a line next to a statement that reads as follows. I do not request discovery of the evidence. I've waived my right to request discovery in this case, and choose to enter a plea of guilty or no contest. Did you place your initials on this location? All right. On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on page 4, which is another document, this document is titled Trial Court Certification of Defendant's Right of Appeal. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have now, Mr. Badgett, before you signed and initialed all of these documents that I showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Badgett, are you a citizen of the United States?
Yes, sir.
State offer states one.
Okay. Now, Mr. Badgett, the state is offering States Exhibit number 1 to be used as evidence in your case. States Exhibit 1 is the first document on the tablet that I show you. This is the same document that have your initials in these 2 locations and your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes.
Okay, no objections. State's Exhibit number 1 will be admitted. Mr. Badgett, are you a citizen of the United States?
Yes, sir.
State?
State offer state one.
Oh. We got to buy more on that one. Kind of lost track. And so this is a question. Mr. Badgett, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Badgett, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is the agreement?
In exchange for defendant's plea, the state's offering 2 days in the Jefferson County Jail with credit for 2 days, and the state would also like to credit those 2 days to the court costs remaining.
Okay. Now, what is this court cost?
I think you got that.
Okay. Will you be able to pay $77 court cost?
Today, no.
Okay, let me do this here. Now, do we, hey. No, she said 2 days credit. Do you have, affidavit of indigence on it in the file? Just hold on a minute. Oh, let me see, I can check and see. Correspondence. Arraignment.
Because the court costs won't be covered entirely by the time, so they only go under one. So he would still have.
Oh, yeah. So, give me just give me an affidavit.
Oh, we don't.
Well, there wasn't one in the, in the court's file. Local jail. Could we, could you get him a affidavit of indigence? You got a clipboard with it on it?
Want him to have a seat right here, Judge?
Yeah, you could have a seat right there.
What, him or her?
No, it's not one I just
Yeah,
looked.
when you're kind of, that's her.
Okay, now, Mr. Badgett,
Yes.
there's a document on there that says Jefferson County Affidavit of Indigence. At the bottom of that document, there's some financial information like monthly expense, well, your monthly income. And if you read it, and then on the other side, they have, he only has to fill out that,
Just his name.
and the bottom portion, and then the top of the first page.
Okay.
Hold on a minute. Hold on a minute. Yeah, okay, this is cause number, court is back in session and cause number 23 CCCR 2006, case is filed in the state of Texas versus Garrett Cody Badgett. Now, Mr. Badgett, I have before me, you were previously sworn in. You previously, entered a plea of no contest to the charge of criminal trespass. You previously acknowledged state's exhibit number 1 and the trial court certification of defendant's right of appeal. You also acknowledged the judge's explanation of rights to defendants without attorney and the waiver for purposes of entering a guilty plea or proceeding to trial. You also stated that you were a citizen of the United States, and you also stated that you are mentally competent to stand trial. Now, the state offered 2 days, credit for 2 days, plus court costs. Court costs in this case is $277. There's a balance of $77 that remains. And so when the court asks if you can pay it, you said you could not pay it today. I have before me a document that is titled Jefferson County Affidavit of Injury. Do you recognize this document?
Yes, sir.
And on page 2 of this document, is this your signature on the line that's titled Defendant's Signature?
Yes, sir.
Now, before you signed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Mr. Badgett, I've read your answers. Based on your answers, the court is going to find that you are indigent. And based on the finding of indigency, the court cost, in this case, will be waived pursuant to Article 42.15 of the Texas Code of Criminal Procedure. Do you understand?
Yes, sir.
Now, Mr. Badger, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Badgett, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Badgett, just have a seat. The court coordinator have to redo the paperwork to include the fact that you are injured and the fact that the court waived the court costs pursuant to Article 42.15.
Thank you, sir.
All right. Here you go. So you're just gonna waive the court costs.
Yes, I am.
Got y'all fixed up.
For what?
You're just missing.
Thank you.
It's,
Was it?
Now, that document basically says that I'm reading a waiver of counsel for purposes of entering a guilty plea or proceeding trial. It says, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Voluntarily means that you're doing it of your own free will. Nobody is forcing you to do it. You're doing it on your own free will, and it's intelligently made. And what you're saying there is that I know what I'm doing. You know what you're doing. So it's the waiver is voluntarily and intelligently made. Furthermore, I have been advised this 27th day of August 2027 by County Court of Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me or for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that's your choice, you will sign your name on the line that is titled defendant, and you will date it today's date, August 27th of 2024. Okay. Now, at the bottom of the previous document, judge's explanation of rights of defendants without an attorney, that second to the last paragraph says, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possessing of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, that is to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, in bold letters, it states, defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you wish to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. If you already have an attorney appointed to represent you, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, August 27th of 2024. Ms. Chapman, do you understand?
Yes, sir.
Okay. You may make
That
your-
was honestly, I don't even know what this is about. And y'all said it's from 2019
Yes, if you,
and Mesquite, Texas, Jen. I've never got arrested in Jefferson County.
okay, let me do this here. Now, Ms.
Chapman, yes, sir.
You have a right to remain silent. Anything that you say can and will be used against you in the court of law. You have a right to have an attorney during any questioning. Do you understand?
Sir.
Before and during any questions. Now, Ms. Bailiff, would you please hand me the document from Ms. Chapman? Thank you. Okay. Did she sign the waiver? And Mr. Hugh? You can have Ms. Chapman. Let me do this here. I have before me a document that is titled Justice's Explanation of, I'm gonna wait for you to finish.
24.
Okay, now, Ms. Chapman, I have two documents before me. First document is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document?
Yeah, the bond is on.
Yes.
Yes,
Is this your signature on the line that's titled
yes,
defendant?
sir.
Or these your initials on the line state you would like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Ms. Chapman, before you signed and initialed these documents,
Mhm.
did you read the documents?
Yes,
Did you understand what you read?
yes.
And is everything in these documents true and correct to the best of your
Oh,
knowledge?
yeah, that one.
Okay.
Yes, sir.
Ms. Chapman, just have a seat at that table and one of the prosecutors will talk to you.
Okay. Thank you.
Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M 326-340. Case is styled the state of Texas versus Wendelin Austin Chapman. Ms. Chapman, is that your full name?
Yes, sir.
Ms. Chapman, would you please raise your right hand? Ms. Chapman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Ms. Chapman, you may put your hand down. How are you doing, Ms. Chapman?
Doing good today, sir.
That's good. Ms. Chapman, I have before me a document on my computer. Well, let's do this document first. I have two documents before me on paper. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Ms. Chapman, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
Defendant?
sir.
Now, Ms. Chapman, before you sign and initial these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Ms. Chapman, I also have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Wendelin Austin Chapman, on or about September 6th of 2019, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Chapman, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Chapman, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you pleaded no contest freely and voluntarily,
Yes, sir.
and are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Chapman, I also have before me a document that is titled Misdemeanor Plea Admonishments on this tablet. Do you recognize this document?
Yes, sir.
On page 2 of this same document,
Mhm.
there are two sets of initials. The
Mhm.
first set of initials is below a paragraph that is titled Waiver, and the initials WC are on a line next to a box that's checked nolo contendere, which means no contest.
Yes,
Did
sir.
you place your initials on this document?
Yes, sir.
The second set of initials is below a paragraph that is titled Discovery Admonishment, and the initials are on a line next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials in the second location?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes,
Is
sir.
this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked.
Mhm.
The first box that's checked states that this is a plea bargain case
Mhm.
and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Ms. Chapman,
Mhm.
before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge?
Yes, sir.
State,
State Office States 1.
Ms. Chapman, do you have any objections? The state is offering State's Exhibit Number 1 to be used as evidence in your case. Is it all right for the state to use this document as evidence in your case? State's Exhibit Number 1 is the document that, let me show you. The first document on the tablet that you acknowledge. And it
yes,
is
sir.
the same document that have your initials in the two locations that you
Oh,
acknowledge.
okay. Yes, sir.
And your signature on page 3.
Yes, sir.
Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Now, Ms. Chapman, are you a citizen of the United States?
Yes, sir.
And Ms. Chapman, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Ms. Chapman, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Ms. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 180 days probated over 1 year, a $300 fine, 60 hours community service plus court cost.
What's the court cost? What's that? Ms. Chapman,
Yes, sir.
the state is offering that you serve 180 days in jail, but you will not have to serve any time in the Jefferson County Jail because you will be placed on probation for 1 year.
Yes, sir.
During the 1 year probationary period, you will be required to pay a fine of $300 plus court costs of $402. You'll be required to pay a probation fee of $6 a month, review analysis fee of $15 a month, and reimbursement fee of $15. Your total monthly installments,
Mhm.
that is the total amount that you will be required to pay each month, is $147 a month. Will you be able to pay the $147 a month?
Can I pay like $80 a month?
Okay, well, Ms. Chapman, let me do this. Ms. Chapman, I have before me a document that is titled Jefferson County Affidavit of Indigence. The
Mhm.
prosecutor's gonna hand you that document. Ms. Chapman, do you recognize that document?
Yes, sir.
On page 2 of that same document, there's a signature at the top left-hand corner that is titled Defendant Signature. Is that your signature?
Yes, sir.
Now, Ms. Chapman,
Yes,
is
sir.
everything on that document true and correct?
Yes, sir.
Okay, Ms. Chapman, the court is going to find that you are indigent. Let's see, let me do this.
Okay.
Okay, here we go.
Yes, sir. in there. Yeah, I do.
Now, she says she can pay about 80. Let's see what this comes out to. Ooh, that'd be $82. Okay. I'm just totaling it up something. Um, okay, Miss Chapman, this is what we're
Yes,
gonna
sir.
do. Okay. The state is offering that you serve 180 days in Jefferson County Jail. However, you're not required serving the time in Jefferson County Jail because you'll be placed on probation for 1 year.
Yes, sir.
During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $402. Now, the court has found you to be indigent,
Mhm.
and based on the finding of indigency, the fine of $300 and the court cost of $402 comes to a total of $702. Pursuant to Article 42.15 of the Code of Criminal Procedure, that will be converted to 56 hours of community service. So you won't have to pay the fine and court costs of $300, of $702. It will be converted to 56 hours of community service. Do you understand that?
Not really.
Okay.
Sorry.
In
I
essence,
think my-
instead of paying
Sorry.
the fine of $300 plus court cost of $402, which is a total of $702,
Yes, sir.
I'm going to convert the fine and court costs
Mhm.
to community service. So you would have to do community service instead of paying,
Okay,
okay?
okay,
And the amount of hours that you'd have to do in community service is 56 hours
okay,
to pay that off, or to
Okay.
work it off.
okay,
all right.
yes, sir.
Now, the reimbursement fee of $15 will be waived. That means that you will not be required to pay it pursuant to Article 102.018. All right, now you mentioned that you can pay about $80, is that
Yes, sir.
correct? So the court, you'll be ordered to pay the probation fee of $60 a month and the urinalysis fee of $15 a month, which comes to a total each month of $82 a month. Will you be able to pay the $82 each
Yes,
month?
sir.
All right. So now, as part of the plea bargain, you're also required to perform 60 hours of community service.
Okay.
Now, that 60 hours of community service will be in addition to the 56 hours of community service that was converted from fine and court costs. So you will be required to perform a total of 116 hours of community service throughout that year.
Okay, I can ask you a question?
Yes,
I'm not sure how that community service works, and I'm disabled, so.
talk to your, well, hold on, let me do this. There's another article. Cut to the chase.
I'm sorry.
No, it's a good thing you brought it up. Okay, okay, let me do this here, let me do this here. Let me do this here, I know I saw, let me see, some 42. This one, I know it's, okay. Trying to get to it, I'm trying this. Oh, I go 4280, I'll direct me straight to it. 42. That's 42. 40. Okay. Here we go. That's 43. Okay. 43.091. 43. 43. It is. Okay. Infinite wave.
Back home.
Okay, this is what we're gonna do.
Yes, sir.
Now, Ms. Chapman,
Yes, sir.
pursuant to article, well, first of all, the court has previously found that you're indigent. Okay? And, you stating to the court that you are disabled. Let me do this here. Pursuant to article 1.24, all trials and proceedings shall be public. However, pursuant to the case of Lilly versus State 365 Southwest Third, 321, the right to public trial is not absolute and may be outweighed by other competing interests, such as the interest of securities, to prevent the disclosure of non-public information and to ensure that the defendant receives a fair trial. Now, based on that case, the court can close this hearing to the public to prevent the disclosure of non-public information, and that's just your disability and all in financial matters or private matters.
Yes, sir.
We are now we're live streaming on YouTube. So to prevent the public from hearing your private matters being disclosed in open court, the court can close the proceeding to the public. And do you want this proceeding closed to the public?
Sure.
Okay.
I've got you basically.
Okay. So the court finds that the party seeking the closure has advanced an overriding interest that is likely to be prejudice to her. This request is no broader than necessary to protect her interests, and the court has considered other reasonable alternatives. And based on these findings, this portion of the hearing will be closed to the public.